Hello, everyone, and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal. Thank you very much for joining us for our webinar today, which is part one in our series on leasing and the legal issues that we commonly see. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners on the land on which our office is located, and we pay our respects to their elders past, present and emerging, and acknowledge that sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. If you haven't joined us for one of our webinars before, or if you have, again, welcome. We hope these webinars are a helpful resource to share with you some of the must-know information and guidance on different topics that may be of interest and that we are seeing in our practice day to day. You can catch up with the recordings and slides for our previous webinars by heading to our website and clicking the link for our resources page. And there you'll find webinars, not just on property law, but also from our lawyers in employment area, in employment law, business law, wills and estates and the like. But today we're continuing to look at an important area of property law and more specifically some of the key things that you need to know when leasing commercial property. And it's an area that seems simple on the surface, but there's a lot of information around and also a lot of options. So it's important to get to the bottom of what you need to know for your own particular situation and premises, both in terms of what suits you best commercially, but also in terms of legal compliance, which is really important, of course. So we hope today we'll give you some more good handles on the key things that you need to know. And I'll shortly hand over to Andre Ong, who will start taking us through today's content. Andre is my fellow principal here at Sharrock Pittman Legal and is an accredited property law specialist. So he has many years of experience in this field and is a consummate expert. And I know he's looking forward to sharing his knowledge with you today, as are Shuba, Ignatius and Crystal from our property team. Before I hand over to Andre, I'll just run through a couple of housekeeping items. We're obviously in webinar mode today, so your cameras aren't visible in the session. You'll be happy to know we are recording the session though, and it will be available on our website soon. And if you do have any questions throughout the session, please feel free to type away in the Q&A box. We'll try to get through all the questions as we go, but we have set aside some time at the end for questions as well. So we're conscious of everyone's time. If we aren't able to get to all of the questions at the end before we wrap up, don't worry, we will get back to you afterwards, and we'll also at the end put up our contact details so you can feel free to send questions through directly. Before we begin, we are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give some general guidance in this session. Everybody's situation is different, of course, and it's really important to keep in mind when it comes to your rights and obligations, whether that's as a landlord or a tenant. So please do keep that in mind as we go through the content. And as I said before, if you have any specific questions, do feel free to get in touch. Also really important to know that and remember that our topic and presentation today is based on the law in Victoria, particularly when it comes to things like the Retail Leases Act. It's all state-based, so do keep that in mind as we go along. So without further ado, I'll hand over to Andre. Thank you, Andre.
Thank you very much, Mitch, and welcome everybody. Firstly, I'll just go through an overview of our session for today. I'll go through some base lease terms and the different considerations there. One of our senior associates, Shuba Rao, will then go through the Retail Leases Act, the difference between retail and non-retail leases. Then Ignatius Sawanto will go through some of those considerations during the term of the lease, the different conditions that can have an impact there. And then Crystal Roman will wrap up in terms of those lease terms that will affect the end of the lease, the exit of the tenant. And hopefully we'll have some time for some questions after that. So moving on to the next slide, Mitch. First off, obviously the key lease term that everyone wants to talk about is rent. At the very start of everything, what's the tenant going to be paying to go in? But beyond the actual number that's being paid, rent is really just a starting point then for the longer term lease relationship. It's really then going to work through issues of what are the reviews going to be over the term of the lease? What about lease incentives at the start to encourage a tenant to commence the lease? So working through reviews, there's fixed CPI and market rent reviews. CPI was certainly quite popular a few years back as inflation was under control and we were getting 1% to 2% CPI reviews from a tenant perspective. That was great. Fixed reviews, though, from a landlord perspective, they were looking at locking in 3 to 3.5%. Basically, that kind of certainty for a landlord that there is that keeping up of rent with inflation and the broader cost of things. Market rent reviews would be usual upon exercise of an option just to recalibrate where the rent is at to the broader market in the particular area. But obviously that's been impacted in the present economic environment where CPI is really ramped up substantially, and it's not unusual for that to now be 6 or 7%. So it's something to think about at the very start of the lease as to which pathway to go down. And the second thing in terms of lease incentives, yes, there is the usual rent-free periods, and from a tenant perspective, not wanting to pay the rent at the outset while you get set up, whilst you get your trade up and running in any particular premises. But from a landlord perspective, that's obviously an issue in terms of not having that cash flow up front. Are there better ways to do it? Is it an issue of perhaps back-ending some of that rent-free period so the tenant is perhaps paying 50% rent over a longer time, or maybe having that rent-free occur at the end of the first year, the second year, so that from the landlord perspective, there is an awareness that the tenant is a good tenant, is meeting their obligations. The other thing to think through is, what about a fit-out incentive instead? So rather than rent-free, the landlord is going to be contributing dollars into the tenant's fit-out cost, and then having that effectively act as the benefit for the cash flow benefit for the tenant, getting them up and running, in exchange for which obviously the tenant will be starting paying the rent earlier on, or in fact up front. Key consideration there is also who's going to own those installations though. So if it's going to be covered by a landlord fit-out incentive, who's going to get the tax benefit, the depreciation of having put that work in, having put those installations in? So it's an important consideration as you start your negotiations in the lease. But just know that as you're considering rent, there are different ways to skin the cat there. Moving on to outgoings as a consideration. A lot of commercial or retail leases are on a plus outgoings basis. So the tenant is going to bear rates, insurance. If it's a commercial lease, then land tax, but if it's a retail lease, then not. All of those things impact what the costs of occupancy are going to be. So it's important to know what you're going to be up for as the lease gets going. There are some things that are usually not claimed, whether it's retail or non-retail. A tenant wouldn't usually be responsible for any structural repairs, any capital issues that are being incurred with respect to the premises. So, for example, the air conditioning breaks down, not due to any action of the tenant. The capital cost of, say, replacing a compressor, if it's a capital item, that a major component of the installation is a landlord installation is failed, well, that would normally be borne by a landlord. If in a commercial lease setting, you're shifting those to a tenant, well, that becomes a point of negotiation, something to work through. But as I said, it is usual for all of those capital and structural items to be borne by the landlord. If you want to go a slightly easier way, but creating some risks, is you can go down the path of a gross lease, which essentially just means the tenant will pay rent and only rent. The landlord will bear all of the outgoings that are payable on the premises. Obviously, from a risk perspective, that means that the landlord is carrying the risk of rates and those costs going up over time. But they'll have the certainty that the tenant is there and hopefully complying more readily. And then maybe you factor that into the way rent increases are going to be applied over the years as well, in terms of working through a fair division of risk. And then obviously there's working through the term and the option terms that you might want. Noting the different perspectives from landlord and tenant. Obviously, the landlord's going to want the longest term that they can have, and the options, basically very minimal, because options are ultimately in favor of the tenant. They don't give the landlord any certainty that a lease will continue into an option term. And the tenant will want the opposite of that, because obviously the longer the lease term is, the more risk they're running in terms of what they owe the landlord over the time of that lease. So it's a balance there between what the landlord and the tenant are after. Certainly what we find is that the usual initial term is somewhere between 3 to 5 years, usually some option terms granted on the backside of that to give the tenant some certainty that they're going to build some goodwill in the premises. Moving on to the next slide. Another key consideration is, well, if you've got a corporate tenant, you should, certainly our legal advice would be that there should always be personal guarantees in place so that there is some weight to those obligations in the lease. From a tenant perspective, if you're trying to move forward without personal guarantees, then it's usually an issue of trying to offer more security, higher security deposit, basically, in order to try and get out of that obligation. With the permitted use, it's important to know, again, different perspectives. If you're the tenant, you're going to want the widest permitted use possible so that you've got flexibility as to how you want to operate your business, maybe introduce other services in there for medical practices, for example. It's not unusual to want to try and include elements of related health services, pharmacy, that sort of thing. If you've got a premises big enough to have those other uses, maybe you don't have it at the beginning, but you want that flexibility. From a landlord perspective, you'd go the opposite way. You'd want it to be narrower. You'd want to have control as to what's going on in your premises so that you have a better understanding of the risk that's applicable. Moving on to landlord and tenant installations, the common issue with this is that very often at the outset, everybody uses a pretty standard sort of list, and they haven't actually applied their thinking into what's in the premises, either already in place at the start or going to be installed by either side. And then you get to the end of the lease, which may be 10 years down the track, and people have lost track of who's put in what, who's got what obligations in terms of removal, in terms of repair, and that's when disputes often arise. The key thing from our advice perspective is to make sure that you've got that list clear and you've got the obligations, especially in a commercial lease sense, when there's a lot more flexibility as to who's responsible for what, that you have it clear as to who's going to be doing the maintenance, who's going to be doing the replacement of things. If the tenant has installed an air conditioning system, for example, in a large industrial property, is that going to stay as the tenant's property to be removed at the end, or actually is it going to be adopted in as the landlord's installation, and the landlord will incur some obligations in maintaining it? So key considerations there. And finally, to close off my bit, security deposit. Obviously, you've got cash, you've got a bank guarantee. From a landlord's perspective, a bank guarantee is the best way to do it because it's a relationship between the bank and the landlord. In the event of any tenant insolvency, the bank will still pay up because that's the nature of a bank guarantee. If you're providing cash, then the issue is going to be, or if you're accepting cash as a landlord, then the issue is going to be, make sure you've got your interest secured on the personal property securities register. Otherwise, that cash could be deemed to be funds in trust held in favor of the tenant, and the liquidator can grab it from you. So having run through all of that, one of the key considerations in all of this is the Retail Leases Act, because that substantially changes the nature of the obligations between the parties. And I'll now hand over to Shiba Rao, who'll go through the Act for you.
Thanks, Andre. Good morning, everyone. So as Andre mentioned, I'm here to talk about the Retail Leases Act for you as to what lease actually fits within the Retail Leases Act to be determined to be a retail lease. So Section 4 of the Retail Leases Act defines retail premises to be a premises not including any area intended for use as a residence that under the terms of the lease relating to the premises are used or are to be used wholly or predominantly for the sale or hire of goods by retail or the retail provision of services. The carrying on of a specified business or a specified kind of business that the minister determines under Section 5 is the business to which this paragraph applies. So the key consideration of when this section actually comes into place would be at the time the lease is being entered into. So there was a bit of, we were in a bit of limbo for a while as to whether a lease can fall in and out of the operation of the Retail Leases Act. There's a case with the Richmond Football Club, and that determined that no, once the lease falls within the regime of the Retail Leases Act, it stays within it. So the key words in Section 4 of the Retail Leases Act is actually the words wholly or predominantly for. the retail or retail provision of services. So wholly is quite easy to understand. It would be the full premises, so 100% of the premises being used for that purpose. Predominantly is the one where there's a bit more of a gray area. And the factors that go into consideration there are, the size of the retail component of the mixed-use business that the tenant is running from the premises, whether the retail component of that occupies the greatest amount of area on the premises, is that retail side generating the greatest proportion of income that would come to the tenant. And also sometimes a couple of cases have actually looked at the time that section of the premises has actually been open for retail trading. So there are a few factors here that need to be taken into consideration to determine whether a mixed-use premises then falls within the Retail Leases Act. There are some exclusions under the Retail Leases Act as well. And so one of, Mitch, if you can go to the next slide, please. All right, so the same section of the Retail Leases Act also refers to particular exclusions. So one of the first exclusions is where the occupancy costs, which being the total rent, outgoings, and other costs payable by the tenant under the lease, exceed $1 million, which is exclusive of GST. Premises that are used wholly or predominantly for the carrying on of a business by a tenant on behalf of the landlord as the landlord's employee or agent. Even this is excluded. Next slide, Mitch. So if the tenant of the premises is a listed corporation or a subsidiary of such a listed corporation, then that lease is also going to be excluded. Where it's also they can also be listed on not just the Security Stock Exchange within Australia, but also outside of Australia, as long as they are a member of the World Federation of Exchanges. And in the next slide, a subsidiary of such a foreign listed company as well would fall within the exclusion. There have been a number of ministerial determinations as well, which seek to exclude various premises. So these have all been come across over the number of years that the retail lease has been in existence. So the first one is if there's a multi-story retail building, the location of the premises is actually important. So if you're within the first 3 floors, so the basement's not counted. So for ground, first floor and second floor, if the premises is within these, then they will be falling within the Retail Leases Act. From the 4th story and above, those premises are excluded. Barristers' chambers as well are specifically excluded. So some 15-year leases are excluded as well, but not just the term of 15 years, the lease must also impose an obligation on the tenant or another person to carry out substantial work on the premises or to incur substantial expenditure on works or improvements at the premises. And the lease must also prevent or disentitle the tenant or the other person from removing such works or improvements that they've undertaken at the premises at the end of the lease. So usually these types of 15-year leases can be leases for alpine resorts, amusement parks, sports and recreational grounds, raceways, theaters, caravan parks, marinas, and youth camps. So recently, a client as well had a petrol station lease that had the 15-year lease term, but that lease still fell within the Retail Leases Act because there was no obligation on the tenant to actually carry out all the works that we mentioned in the determination. So while those works were sort of discretionary on the tenant's election, and so that's why it fell out of scope of that particular determination. So market land as well, as defined under the Melbourne Market Authority Act, excuse me, 1977 is also specifically excluded. Local council premises that are used for community or charitable purposes are excluded. So there's two of them that relate to similar types of premises. So there was one determination that applied to the period 1 January 2015 prior to that, and one that applied after. So the one that was after, so like the rent has to, for these premises, need to be $10,000 per annum or less. And the use is for community or charitable type of purposes. We've already covered there was a specific determination as well about the listed entities, because there was one country where the stock exchange was no longer part of the federation that we mentioned before, and so now any foreign listed entity will fall within this particular minister's determination and be excluded. Premises that are also used for commercial gain from farming or agricultural purposes as well are excluded from the Act. The Act also at Section 12 does refer to a lease term that is less than 1 year. So if you do have a lease that's less than 1 year, then the Act is not actually going to apply to the lease. However, if the actual tenant is in possession of the premises for longer than a year, either by the lease being renewed or the lease being continued, and the tenant has been in continuous possession of the premises for 1 year or more, then the lease will apply from the day that the tenant has been in continuous possession of the retail premises for 1 year. Next slide, Mitch. Thank you. So now we're just going to look at some cases here. So in terms of the landmark places that we've had, although these principles, I guess, have been around for a number of years, there has been changes in recent years as to how these are interpreted by the court. So the ultimate consumer test has been around for many years, and that's generally how people would and practitioners would look at and consider whether a property would fall within the retail premises definition. In this case, CV storage, there was a change in respect to how that was actually interpreted. So in the ultimate consumer test here, it was determined that premises used for supplying commercial services to other businesses who are determined to fall within the Retail Premises Act. So prior to this, business-to-business transactions were not treated as retail leases. So this case did turn it around there. And some of the factors that needed to be considered is what type of service is being offered. Is there a fee being paid for that service? Is the service generally available to anyone who is willing to pay a fee? And whether the persons who use the service are the ultimate consumer. In this case, the tenant conducted a business of a cold and cool storage warehouse from the premises. And this was in line with the permitted use of the lease as well. The tenant's customers ranged from large primary production enterprises to very small owner-operated businesses. So at the initial stage, VCAT said that these premises were not retail premises, as the consumer was not a person who was going to be using the products to satisfy their personal needs, but rather it was being done for a business purpose. So when it went to the Supreme Court, this was held that it was in error, that the actual customers who were receiving it for a business purpose were not ultimate consumers. And so the Supreme Court said that, yes, a business using these services would be treated as an ultimate consumer. So not just the ultimate consumer test, premises are the factors that we can actually look at whether the premises falls within the retail lease as well, is also whether the premises is open to the public in general. And there are two cases that we can listed there for you, which which discussed this. So bulk powders was one of the first cases that looked at this provision in further detail as to whether how open to the public premises is a main determinant as to whether the premises falls as a retail lease premises or a commercial lease one. So in this case, the premises was being used for production, packaging, and storage of health supplements. So it was not retail by nature. It was the supply of powered food and nutritional supplements for weightlifters, bodybuilders, and other athletes. And so the tenant argued that the business was retail because its supplies satisfied the ultimate consumer test, as most of its consumers were directly consuming its product with a small amount of wholesaling. But the tenant also gave evidence here that most of the business was conducted online, and the members of the public were not allowed to access the premises, in part because the premises was one of its competitors had actually burnt down, and evidence suggested that there might have been an arson attack, so for security purposes. And a small number of well-known customers were allowed to access the property by invitation only. So in the members' finding here, she heard that the premises was not actually open to the public, and it was actually not a retail premises there. There was no signage at the premises identifying it to the public that it was the premises of the tenant. There was clear that they didn't want the location of the premises to be publicly known due to the fires, and only certain restricted clients were allowed to enter the premises there. So the fact that it was also a lot of sales were being done online, that was also related to the fact that it was actually not open to the public there. So with the next case, Eastcom, so it was quite similar with there as well. The tenant there had a warehouse and sold different types of stainless steel products to customers. So although the tenant preferred pre-arranged sales, sales were also made to members of the public without pre-arranged sales meetings. But when they had such meetings, a salesperson would meet the customer in the office and escort the customer through an internal door to the warehouse. Members of the public could enter the premises through warehouse doors, but they were only open from certain times during the day, which was only about half an hour. And staff would always be available to escort any members of the public. Business signs were placed outside, but they were minimal. And purchase of the products could either be made in the warehouse or in the office. The warehouse was also located in an industrial park, and the industrial park did not list the tenant's business on its signage. So the member there held that the lease was not a retail premises lease, as the ultimate consumer test was not satisfied, and the premises was not open to the public in the required sense. And so the member applied the test in CB cold storage. Next slide, Mitch. So just in terms of some takeaway points for landlords and tenants. So the application of the acts is on a case-by-case basis, and it turns on the actual use of the premises. And so the breadth of the ultimate consumer test is wide, and it should be taken into consideration by the parties. There's also a school of thought that if there's an element of doubt as to whether a tenant's use of the property might fall within a retail premises type of scenario, it might be best to treat the premises as a retail premises lease to prevent any clawbacks from a tenant in the future. And there's also the tribunal's also the tribunal's approach is also a practical one in considering the factors that need to be applied. I will now pass you to my colleague Ignatius, who will discuss the impact of the classification of a lease as a retail lease or a commercial lease.
Thanks, Shubha. Now, Krista and I will take you through what it means to have a retail lease rather than a non-retail commercial lease. We will explore what are the additional rights and obligations imposed by the Retail Lease Act on the terms and conditions of the lease. First, I will be talking about the distinction during the negotiation period and during the life of the lease.
And I'll also be talking about the distinctions that come at the end of the lease, which will include make good obligations, what happens where there's a transfer, and a surrender of the lease as well.
All right, so for the first, during the negotiation of the lease, the Retail Lease Act provides that the landlord has to, as soon as possible, provides a copy of the proposed lease and the VSBC information brochure. As this is at the very early stage of the negotiation period, the details for the lease does not need to be included in the first copy of the proposed lease. So like the particulars for the tenant, the rent, or the terms of the proposed lease does not have to be finalized at this point. It has to be provided to the tenant. And for the VSBC, is the Victorian Small Business Commission information brochures. It can be obtained from their website. And next, after a few negotiations, the landlord is required to provide the tenant with a proposed disclosure statement and the proposed lease with the details of the tenant particulars, rent, and other key considerations. And this has to be provided at least 14 days before entering into the lease. And the disclosure statement, in brief, is a document that contains the key terms of the lease, such as the rent amount, the terms, how many options are available for the tenant, and what are the dates important for the tenant to exercise those options. And also, more importantly, it also contains the expected outgoings that the tenant has to pay to the landlord during the life of the lease. And because as we talked before, the landlord can have to provide the proposed lease at the earliest stage of negotiation. And at this stage, if the landlord gives another lease, the landlord has to notify the tenant if there are any changes to the previous copy of the lease that the tenant has received. While this requirement seems to be a formality, it is important that the landlord complies with this requirement, because if the tenant has not been given a disclosure statement, the tenant may give the landlord no earlier than 7 days and no later than 90 days after entering into lease a written notice that the tenant has not been given the disclosure statement. And this has serious consequences because, one, the tenant may withhold payment until the day on which the landlord gives the tenant the disclosure statement. Or two, the tenant is not liable to pay rent attributable to the period from and including the day on which the notice was given, and until and including the day on which the landlord gives the tenant the disclosure statement. Or C, the tenant may give the landlord a written notice of termination at any time before the end of 7 days after the landlord gives the tenant the disclosure statement. Second, there are terms that is imposed by the Retail Lease Act to be considered implied or included in your lease. For example, the first one and the most important one, the term of a retail premise lease, including any further terms provided by an option, must be at least 5 years. This means that if you have a 2 years lease, but you also get 2 further options of 2 years each, the total terms in this lease is 6 years, and it satisfies the requirement of minimum 5-year terms. If the lease is shorter than 5 years, you can agree between the landlord and the tenant and ask the tenant to obtain a PSBC 5-year waiver certificate to ensure that the party knows that they are entering into a lease that is below 5 years. And another example to obtain the 5 years waiver certificates is if you have a lease for 5 years, but the lease itself provides conditions or circumstances in which the landlord may issue a notice to the tenant to terminate the lease prior to the end of the 5 years. This caution should be given in this kind of circumstances because the effective terms of the lease will be less than 4 years in that particular circumstances. And there's one exception to the rule is if the lease is under a head lease. So the minimum term is the term of the head lease minus 1 day if the term is less than 5 years. Next is this a provision for the landlord's fit-out period, which applies if the landlord has obligation under the lease to provide some or all of the fit out before the tenant enters into possession of the premise. First, the Retailist Act provides that the tenant is not liable to pay rent or any other amount under the lease in respect of any period before the landlord has substantially complied with the landlord's obligation concerning the fit out of the premise, and more importantly, except on reasonable grounds of safety, the landlord is not entitled to deny the tenant possession of the premises merely because the landlord has not complied with the landlord's obligation. Next is the key money prohibition, which means that the landlord must not seek or accept the payment of key money or any consideration for the goodwill of any business carried out at the retail premises. So what is key money? It is simply a key money request is simply where a landlord asks the tenant to make a payment in addition to any rent, bond, or payment for services in order to get the landlord consent to grant the lease, vary the lease, renew the lease, or assign the lease. So for example, if a landlord is seeking payment of $10,000 from the tenant before giving the tenant access to the premises at the start of the lease, this payment is likely to be a key money and is prohibited by the Act. Or another circumstances is like where a landlord agrees to consent to assign the lease to a new tenant if the existing tenant first paid the landlord $10,000. The existing tenant receives nothing in return other than the landlord's consent to the assignment. This payment is also likely to be key money and is prohibited by the Act. Next, I'll talk through the difference that the retail lease imposes during the life of the lease. First is for the outgoings. It is important that it is drafted in negative, in which the Retail Lease Act provide that the tenant under a retail premise lease is not liable to pay an amount to the landlord in respect of outgoings, except in accordance with the provision of the lease that specify 1, the outgoings that are to be regarded as recoverable, 2, in a manner consistent with the regulation, and 3, and how those outgoings or any part of them may be recovered by the landlord from the tenant. So remember the disclosure statement that I was talking before. It is important to include all the outgoings that is to be recovered from the tenant because of that reason. Next is the list for the outgoings that are not recoverable from the tenants from the Retail Lease Act. First, the capital cost, as Andre has previously mentioned, air conditioning and other structural items are usually landlords, and the Retail Lease Act prohibit expressly recovery of capital costs. There's one exception, which is for the essential safety measures, which may be recovered from the tenant if the lease and the disclosure statement enables the recovery of the ESM. Next, I just touch base on the landlord's legal costs, which is not recoverable for the negotiation and preparation of lease and renewal of lease. But please note that the landlord still can claim legal and other costs for the assignment of lease, surrender of lease, and in case of a defaulting tenant, the landlord's cost of enforcing the landlord's right under the lease. And next, I'll just briefly touch that the landlord's liability for repairs that the landlord must bear responsibility to pay for the structure and fixture repair, and the landlord is only not responsible for the repair cost if the needs for the repair arise from the misuse of the tenant. I know that there is other prohibition from the Retail Lease Act on the refurbishment, relocation, and demolition, but due to the time constraint, we will discuss it another time. Now I'll pass it to Crystal.
Hello, everyone. Now we've come to the end of the lease, and we'll be discussing the differences at the end of the lease stage that we see between retail and non-retail leases. As always, the retail leases must be drafted and performed in accordance with the Retail Leases Act, and they also pose certain obligations on tenants and landlords at the end of the lease stage. The non-retail leases you'll discover generally have similar conditions as retail leases, but are governed by general contract laws and are generally more determined by what the parties actually agree to at the negotiation stage of the lease. So we'll start off with the make good obligations, as they are an extremely important feature of all leases. So what is the make good clause? A make good obligation requires a tenant to leave the premises at the end of the lease in the same condition as it was originally provided. So this means that generally a tenant is required to remove their fit out and any property when the lease is over. In practice, making good requires the tenant to leave the space clean and tidy, and is also required to repair any damage that was caused to the premises and has been caused during the duration of the lease. It also requires the tenant to remove fixtures, installations, and floorings that have been installed. However, sometimes you'll find that landlords actually like the fit out in the premises and request that the tenant not remove it, and this can be something that is negotiated at that time. However, with that being said, and as Ignatius just touched on before, the landlord is actually responsible for maintenance and repairs on the premises, which will also apply to the make good obligations. So as Ignatius just touched on, Section 52 of the Retail Leases Act states that the landlord is responsible for maintaining the premises in a condition consistent with the conditions of the premises when the lease was entered into. So the landlord's maintenance and repair obligations also include repair and maintenance of the structure and the fixtures in the retail premises. So this can be the walls, the roof, inbuilt shelving. The landlord's also responsible for repairing and maintaining plant and equipment at the premises. So for example, air conditioning and the appliances, fittings and fixtures provided under the lease. So this can be hot water systems, for example. So what this section means is that essentially a landlord must repair and maintain a property to a standard that it was first provided to the tenant. We've used the air conditioning example a lot in this webinar. So if the air conditioner breaks under a Retail Lease Act, the landlord's obligation is to fix and repair this. However, the Retail Leases Act also provides that the landlord is not responsible for maintaining and repairing faults if the fault or defect arose from a misuse of the tenant. So it's always crucial to remember that if a retail lease includes provisions that obligates the tenant to complete repair and maintenance, that should actually be the responsibility of the landlord under the Retail Leases Act. The Retail Leases Act will actually override the lease, and that provision may be considered an unfair lease term, and the landlord may be in breach of the Retail Leases Act. So a non-retail lease also has make good obligations. However, the obligations of the tenant and landlord can be different from retail leases, as a non-retail lease will generally be negotiated. The provisions of the make good obligations will be negotiated between the parties before they enter into it. So just like the retail lease, a non-retail lease make good obligations require the tenant to return the premises to its original state prior to its commencement. However, the lease will specify what the tenant's make good obligations are, which may actually deviate from a retail lease where the landlord would be responsible for certain repairs. So in a commercial lease, for example, the landlord may not be responsible for repairing a broken air conditioning system, and it's instead the tenant's responsibility to do so. It's always important to carefully consider your make good obligation clauses, whether you're a tenant or a landlord. Otherwise, there can be significant expenses to either party at the end of the lease. Both the landlord and tenant are able to negotiate a make good obligation, and negotiations may depend on the use of the premises, the location and length of the lease, and the type of fit out that the tenant plans on installing at the premises. As most make good provisions generally require the tenant to reinstate the premises to its original condition, we recommend obtaining a condition report prior to the commencement date to ensure that make good obligations are met. This condition report should document the condition of the premises when the premises was handed over to the tenant, and also establishing how the premises must be returned at the end of the lease. So now, one of the ways to end a lease will be via transfer, also known as assignment of the lease. So transfer or assignment occurs when the lease is transferred from a previous tenant to a new tenant during the term of the lease. In retail leases, the procedure for transferring a lease is of course set out in the Retail Leases Act. So Section 61 of the Retail Leases Act actually provides the procedure that is required to be followed if a transfer and assignment occurs. So the tenant firstly must request the landlord's consent to an assignment, and the request must be in writing, and the tenant must also provide the landlord with information as the landlord reasonably requires about the financial resources and business experience of the proposed tenant. So this can be things such as financial statements or references as to the way that they've conducted their business. Now, the Retail Leases Act also states that before requesting the landlord's consent, the tenant must give the proposed tenant a copy of the disclosure statement, and if any changes have been made to the disclosure statement, a copy of these changes as well. However, with the Retail Leases Act, if the tenant requests the landlord to provide the disclosure statement and the landlord refuses, the tenant then is no longer obligated to provide the proposed tenant with that disclosure statement. So after the landlord has been provided with the requested documents, the landlord must actually deal quickly with the request to consent. They can't just sit on it and hope that the request goes away. So importantly, the landlord is taken to have consented to the assignment if the tenant has complied with its obligations under the legislation and the landlord has not, within 28 days of receiving the request, that they have not either given notice to consenting or withholding consent. So even if the landlord doesn't reply within 28 days, it's considered that the landlord has consented to this transfer. So as a landlord, it's really important to be on top of these matters when they come to you and to take steps quickly to either consent, withhold, or review all the information that has been provided to you. So as we can see, the Retail Leases Act provides the procedure that must be followed when a tenant is transferring or assigning the lease. It also provides circumstances on when the landlord can withhold consent to an assignment, and some of these circumstances briefly can be where, for example, if the business that's planning on taking over is brand new and financial resources may be a bit lower, or their business experience, their references that don't have that much business experience. So what the landlord can do is actually, for example, request further security to be put on the property. So with the commercial leases, the procedure to assign the lease is effectively the same. However, it's determined by the lease provisions themselves. So tenant must first ensure their lease provisions allow them to assign the lease. And it's important for both tenant and landlord to think about this provision when negotiating the lease to ensure their interests are protected as best as possible. So some things that would go into the negotiations would be tenant obligations, what the landlord actually requires, negotiating a time frame within by which the landlord must provide their consent. So similar to the Retail Leases Act, however, it's actually provided in the lease to a greater degree of certainty. So now we've come to another way of ending the lease. So that will be via surrender of lease. So surrendering the lease may occur when the tenant and landlord wish to end the lease prior to the specified expiry date. And it's important to note that both landlord and tenant must agree to this in writing, and it be formalized by a deed of surrender. So the terms of the surrender are generally negotiated between the tenant and landlord, and it's important to remember that the landlord has no legal obligations to agree to the surrender and will usually negotiate the surrender terms in their best interests. So whether the lease is retail or non-retail, where a tenant wishes to end their lease early, they must carefully read and consider the lease provisions to do so. What happens when the tenant ends their lease early? Well, it's normal for the tenant to compensate the landlord in some way or another. These terms are negotiated between the parties. And for example, a landlord may request that a tenant continue to pay rent until a new tenant is found, or for the tenant to pay the costs of releasing the property, which includes the landlord's advertising fees and other reasonable expenses incurred by the landlord. The landlord is also has an obligation to actively try to lease the premises as quickly as possible. As I mentioned before, the terms of the surrender must be written down and formalized by way of a deed of surrender, and this deed will outline how the lease will end, the tenant's and landlord's obligations, the sum of money that the tenant will pay, and any other agreed upon terms. In terms of a retail lease, the Retail Lease Act states that where a tenant performs all of its obligations, the landlord is required to return the security deposit to the tenant within 30 days after the lease ends. Therefore, when a tenant surrenders the lease, the landlord is still required to return the security deposit, provided that the tenant has fulfilled all of their obligations, including the obligations as determined in the deed of surrender. We'll pass it back to Mitchell.
Thank you very much, Crystal, and Ignatius and Shuba as well for sharing all of that content. We do have time for a couple of questions if anyone has any. None have come through as we've gone along, which is fine, of course. Andre, did you have anything else to add while we're seeing if any questions come through?
Yeah, whilst everyone's, I guess, thinking of any questions that they might ask, just to pick up a little bit on that surrender side of things, because it's certainly something that is coming up a bit more frequently from our end of things. We've got, I guess, in a more difficult economic environment that we're entering into, a lot more tenants that are looking to either move on, reduce costs in terms of other premises, or on the flip side, some of them may well be expanding and looking for larger premises. It's some of those aspects in terms of negotiating terms with your landlord that Crystal was raising that needs to be thought through at the earliest possible point. Certainly had situations where even on a lease renewal, a client has come in to see us knowing that they will have outgrown their premises within the first year or two of a 5-year term. While in that situation, they'd exercise their option. It was already a little bit too late for us to be meaningfully inputting into any kind of renegotiation of the renewal. But at that point, it was important for the client to become aware of what their actual obligations were going to be on exit. If they're going to think about breaking the lease early, at what point they need to be working out their arrangements in terms of funding so that there is enough there to cover off those landlord obligations, bearing in mind their usual personal guarantees in place. So you don't just get to walk away and leave the landlord holding the bag. It's an issue of negotiation, and the earlier, the better in that sort of situation. So it's just that there's obviously that greater mobility that people are looking at this point in time, and these things have to be thought of, at the earliest possible point. And then picking up another general provision in terms of outgoings and Retail Leases Act, most landlords, hopefully, would be doing their annual disclosures to tenants of the estimate of outgoings that are payable on their particular premises. And as a bit of a unfortunate upshot, if you don't do the proper disclosure, is that there have been VCAT cases where landlords have been forced to disgorge outgoings that have been paid by a tenant because there has been a failure to do that annual disclosure. The Act's obligations are clear, and if there's any breach of those obligations in terms of proper disclosure, tenant doesn't have to pay the outgoings. So there ends up being a dispute about that. So with all of these aspects, it's just an issue of making sure you know where you stand. So I would encourage, whether you're a landlord or a tenant, to when these issues arise, get some legal advice and know where you stand as you head into any particular area or request that a tenant is raising, or that you might want to do as a tenant, to make sure that all those I's are dotted, T's are crossed, because they have substantial real world ramifications. The other thing, referencing back to Shuba's part of the presentation with respect to the bulk powders case, that did create effectively a new public access requirement in terms of determining whether something was retail or not, as the ultimate consumer test by itself created a very wide category in terms of what would be factored into a retail lease. But bulk powders effectively created this additional requirement. So we have actually had circumstances where clients of ours who had previously decided that they were retail or should be retail because of the CB cold storage decision have ended up later on, after bulk powders being in a position where they should decide, actually, maybe they've gone, these are landlords, maybe this is more of a non-retail lease situation, which obviously in an environment of rising land taxes, and not least of which, is a very positive thing in terms of trying to claim that. But obviously you're then going to kick off a dispute with the tenant. So these are all things to be thought through in terms of the proper characterization of those issues. So those are just a little bit of, I guess, highlights and takeaways over what has been discussed here and what might impact your practical day-to-day as a landlord or as a tenant.
Thanks, Andre. Yeah, it's often that practical stuff that sometimes is very helpful, isn't it?
Absolutely.
And just following on from that, everybody, we do have a lot of other resources on our website and our social media channels there. Of course, you can follow. We are constantly publishing articles in this area as well as across the practice, of course, based on developments that are happening. The law is constantly changing and evolving, of course, but also some of the frequently raised issues and queries that we're getting in different areas. So here's a bit of a selection of some of the recent articles in property law specifically, all available on our website in the resources tab. And as new ones get published, we will push those out, particularly via LinkedIn, Twitter, and Facebook. Finally, a couple of things before we wrap up. And a quick plug, if you'll allow me, if you're interested in looking at how a systems approach can help drive excellence and high performance in your business or organisation, very important at the moment, I think. A reminder to take a look at David Sherrock's book, Fighting for Enterprise Success Through the Eye of the Tiger, which is in ebook and hard copy formats. Lots of wisdom, guidance, and reflection from David, as well as about 70 odd self-assessment tools, templates and samples, including many that we've developed in our own practice just to give a little bit of guidance, and we've made those available. So I might seem biased, but really is a terrific tool and resource for getting across all of business fundamentals to not just survive in business, but thrive. And of course, that's what we all want to do, don't we? So just also letting you know about part 2 of this series on leasing. This was part 1, of course. Andre, do you want to say anything about part 2?
Sure. So part 2, obviously there's a few months between then and now, but at the same time, we'll be holding many more webinars with respect to our different practice areas to be inputting into all of your businesses. But part 2 of this leasing series will delve into more of a hints and tips of issues that our customers have run into. Save yourself the learning the hard way and learn it from us, in effect. As people are aware also, the process for renewing a lease has changed. There's earlier notice requirements. There's issues of having to negotiate the market rent earlier, in effect. So those things are relevant for people to consider. But mostly we'll just be running through some case studies of disputes that have arisen. Learn from the other problems that are out there and hopefully avoid them for yourself.
Thanks, Andre. So pencil it in, everybody. We'll circulate invites and links for that as we get closer to the date. But that brings us to the end of today's session. Thank you very much, Andre, Shuba, Ignatius, and Crystal, and thank you all for joining us. And as we said before, if you do have any queries on anything that we've covered today or haven't been able to cover today, please don't hesitate to contact us on the details there on your screen. And you can also find all those contact details on our website, of course. So in the meantime, thank you very much, and we wish you all the best and have a terrific rest of the day. Thank you.